Morning, everyone. Thanks for joining us. Still waiting on a few people to dial in. So good morning. Hopefully we'll get underway shortly. Numbers are building up, so thank you very much indeed. We'll be kicking off shortly. Thank you. Morning, everyone. It's just after 10, so I think we'll give it a couple more minutes. The numbers are still rising quite nicely. I'm thinking and I'm hoping all the presenters have now been able to join as well. Otherwise, people will have to listen to me for the next hour and a bit, which is nobody wants. But if we give it one more minute, if we may, just to allow everybody to join in case they're having some difficulties, and then we will start in the next. Thank you very much. Okay, it's just after 10, and we've got a good number of people on the call now, and we've got quite a tight time scale, quite a tight agenda. There's a lot to include, a lot to fit in, so I'm going to kick off now. So really, I want to say thank you to everyone for joining us this morning, taking time out of your busy day to sit down and listen to what we've got to tell you. My name is Carl Tapman. I'm the head of claims relationship at ZM. And I'll be sort of hosting the session today, but colleagues from claims will be delivering the message. The experts will sort of get their chance to tell you all about the various topics that we're covering. Just a bit of housekeeping. Everyone that's joined, apart from the presenters, your cameras are switched off and your mics are muted, but we do want you to get involved. We do want you to interact with us. So if you do have a question to raise, please could you do it in the chat facility at the top, which we'll then take away and collate. If we can answer them on the call, we will do. If not, we'll sort of come back to you when we share the recording and the slides along with a survey at the end. So if you've got any questions that arise as you're going along, if you just could note them down in the chat facility, and we'll then answer them and address them as soon as we possibly can, either on the call or thereafter. So hopefully I can get my slide deck to cooperate, and we'll give you a bit of an overview on what the agenda is. If somebody can confirm that my slides are changing, that will be appreciated.
Yeah, we can see the agenda page.
I'll take silence as. Oh, okay, that's great. Sorry, I can't see myself now. Now I'm starting to show. So that's just a bit of an overview of what we're going to be covering this morning. We're going to touch on the official injury claims portal and give you a timeline of what's happened, what's gone on, and what the future holds. Same with fixed recoverable costs, what the changes are, but what it means in practice and what we're thinking we're going to see. We have a session on contractors to cover highways, landlords and tenants, occupiers liability, and some best practice suggestions. touching on the subject of e-scooters, what the legal position is and what the guidance is, and what we think and what we anticipate may be coming our way. And then finally, an update on specialty claims, some sort of recent high-level important court decisions in relation to the vicarious liability and the duty of care. So, enough from me. I'll now pass on to Martin and Jennifer.
Good morning, everyone. Yeah, good morning, everyone. My name's Martin. I'm going to take you through what we've seen since the introduction of the OIC portal, and then I'll pass over to my colleague Jen, who will look at what's happening next year and what we may be flagged up as a consequence of that. Carol, can we move on to the next slide, please? So since the introduction of the OIC, there was many objectives that it had when being introduced, one of which was providing easy access of justice to direct claimants. Previously, within the MOJ, they would need to be represented to pursue their cases. So this provided them an online portal to pursue the cases directly with ease. And when you look at the process between unrepresented and represented claimants, unrepresented claimants are definitely going through a lot quicker, from the notification to obtaining the medical to agreeing settlement. That process is a lot quicker when they're unrepresented. But what we've not seen is that uptake. So in OIC's last figures, less than 10% of the claims that have went through the OIC portal have been by unrepresented claimants. So there's probably still a bit of work to do there. Another area was reducing the settlement costs for whiplash injuries. Within the MOJ, they were slightly inflated, so the structure was provided to have set amounts for prognosis periods to sort of limit the costs there. And that's happened. You look at the latest figures, £731 is the average settlement for sort of whiplash injuries for represented, and £738 on average for unrepresented claimants. Those cases would have settled at a couple of £1,000, so there has been a drop there. But what it doesn't take into consideration is the increase in sort of non-tariff injuries, so non-whiplash related injuries that we've seen. And I'll go into that in a little bit more detail. So with the changes that have come in, it was inevitable that solicitors' behaviour and claimants' behaviours were going to change. So we have seen a sort of reduction in the injury claims, the frequency of these claims being presented. Initially, it was thought it was due to potential COVID restrictions that were still on and off at the time. Then there was potential issues around the actual OIC system and whether solicitors were using it in the right way and whether direct claimants were able to use it in the right way. But over time, the frequency of the claims increased and they've now sort of levelled off, so that we think the frequency drop that we've seen when comparing it to the MOJ is likely to stay based on the current rules that are in place. Another change that we've seen is the delay in sort of providing the medical evidence. A couple of issues, again, could have been relating to the system issue initially, but they've all been fixed. So we're still seeing the delay in medical reports coming through. So it could be in relation to outweighting prognosis periods, but it could also be linked to how you actually value an injury case when you have a tariff and non-tariff elements, or whiplash and non-whiplash injuries. And even though we're over 2 years down the line, that's still ongoing, and that's the last point that I'll touch on, which I'll go on to next. But the biggest change that we've seen within the OIC since its introduction is that increase in non-whiplash injuries. So previously within the MOJ, the majority of cases were whiplash only for the sort of low value cases, with potential some chest injuries, abdomen, and some hips on rare occasions. But what we're now seeing within the OIC is that the majority of cases have non-whiplash related injuries, but they tend to be elbows, wrists, knees, ankles, so things that we hadn't previously seen. The way that vehicles are coming together and accidents are happening, that hasn't changed between MOJ and OIC. So there's no clear indication of why the people are being injured in different ways to what we've previously seen. So it could be that it's just an aim to sort of get increased costs. So when you look at cases and we are able to identify that these injuries, the non-tariff injuries, are relevant, it's how you go about valuing it, and that's something that's still ongoing at the moment. There was test cases through the Court of Appeal earlier this year on how to direct people or direct insurers and solicitors about how these cases should be valued. But this has then been challenged, and it's due to be heard at the Supreme Court in February next year. So that is still underway, and we'll just need to see how that develops. I'll just pass over to Jen.
Thanks, Martin. So yeah, I'm going to look ahead to 2024. So it's been confirmed the review of the Judicial College guidelines will take place in May next year. And we could see this amount increase by 20% or higher. The whiplash tariffs are also set to be reviewed, and it's been suggested that these could be increased by around 10 to 13%. However, initial valuations were set to cover a 3-year period, so that the tariff amount isn't reviewed every year, and therefore we can't rule out there being a higher increase to cover the next 3 years. Depending on the increased amount, as a knock-on effect, we might see more cases going over the £5,000 limit of the OIC portal and ending up in the MOJ portal. We are already seeing some solicitors arguing cases should be within the MOJ portal due to the valuations of the non-tariff injuries, and this is something that we can expect to become more prevalent with potential increases to general damages. We are working with our panel of solicitors to identify cases we can run to trial in these circumstances. In terms of solicitors, there are fewer firms dealing with OIC cases than had been dealing with MOJ claims. This was expected, and more recently we have seen solicitors pulling out of the OIC market altogether. For example, earlier this year, Slater Gordon stopped handling cases within the OIC, and their work was transferred to Carpenters, who were already one of the OIC's biggest players. It's believed we will see more of this merging as time goes on. Also, with the potential increase in settlement values, we may start to see more accident management companies becoming involved. This was anticipated initially, but it never came to light due to the low value tariff amounts. With regards to litigation, this has been low so far, likely due to the limited costs available to solicitors acting and the time spent to pursue the cases. It is thought that we may see an increase in litigation going forward with the potential increased value of general damages. Furthermore, we will have cases approaching their 3-year limitation period next year, so those sitting with a liability or a quantum dispute may be litigated to be resolved. So, in conclusion, being a relatively new process for dealing with personal injury claims, the OIC has gone through many changes over the last couple of years, and we would expect that to continue into 2024. So we will continue, as we have done since go live, to closely monitor any emerging trends and implement strategies where we need to. So thank you very much for your time today, and I will now hand over to Suzanne and Mike to cover fixed recoverable costs.
Thank you, Jen. Just waiting for the slide to change, Carol.
It should have changed over to the headline slide.
That's
Suzanne,
it now. Thank you. Yep, just checking. Yeah. All right, thanks everyone. So I'm Suzanne, I'm a manager in a personal injury and a credit hire team as well in Zurich. So I'm just going to cover off the headlines of the fixed recoverable costs. So from the 1st of October, the costs have been extended for claims up to £100,000, for claims between £25,000 and £100,000. So this has been seen as the biggest change in civil justice for a decade, and essentially since the MOJ portal was originally introduced. There's been an introduction of a new intermediate track for cases valued between 25 and 100,000, and this is with the intention to create a more streamlined process for litigation. There are many other changes, such as a provision for an uplift in cost if the claimant has a vulnerability that has an impact on the solicitor's time spent on the case, and also a change to Part 36 offers, whereby the claimant could receive an uplift of costs up to 35% if they were to obtain a judgment against the defendant, which meets or exceeds their own Part 36 offer. So today, just wanted to really highlight the headline changes and a brief overview of what this means for our day-to-day claims handling and how it provides us with a clearer position of the costs pre and post litigation. So the new costs will apply to all claims where proceedings are issued on or after the 1st of October, except they will not apply to any personal injury claim where the accident occurred before the 1st of October, or disease claims where a letter of claim has been sent before the 1st of October. So this means essentially that any non-injury claim issued after the 1st of October, it will be dealt with under the new cost regime, regardless of when that was intimated. So this is good news for higher value credit hire or property damage claims where the costs are attached. So on top of the introduction of the intermediate track, there's also some complexity bands attached to both the fast and the intermediate track. So these are very dependent on the type of claim and the stage that the claim actually settles at. So an example is within the intermediate track, if there's more than one issue at stake, such as liability and quantum, then this would move from what could have been a complexity band 1 cost to complexity band 2. And there's also additional costs for vulnerabilities, and cases can be moved through the bandings if there's certain complexities of both cross tracks as well. So I'll quickly talk you through a couple of claims examples, and just to note the 2 examples here don't include any disbursements. So firstly, if we were to look at an MLG motor claim, which is valued at £6,000, so the costs attached to that are £900 if that was retained in the portal. However, if this one had been exited and then subsequently settled at a later date, the cost would now be £1,740. Or if we look at an MLG public liability claim, if that was valued at £15,000, the cost would be £1,920 within the portal. However, if that was exited and then subsequently settled at a later date, we'd be looking at £4,200 for those costs. So it's quite a difference. So I just hope that this sort of demonstrates the benefit of keeping a fast track claim within the MLG portal wherever possible. So any prompt report of new claims and supporting us with any liability evidence, sort of statements, sketches, accident report forums, witness evidence, CCTV, anything that can help us to support a denial and basically making the right decision within the set timescales is a great help to us, and also just allows us to assess whether or not we would prefer to keep the case in for the fixed costs within the MLG portal, or allow us to sort of deny that and take it further. So I briefly mentioned that insurers will see the benefit within some higher value cases with the introduction of the costs. So I've got another example here of a personal injury claim that settled at £75,000 earlier this year. So the costs were assessed and agreed in the region of £18,000. Had this case been subject to the new cost regime, they would have been fixed at £4,620 in band 1 or £11,400 in band 2. So again, just another example of how we can sort of predict the costs that would be attached to these higher value cases and the benefit to the fixed recoverable cost for us as insurers. So this was a very brief overview of the changes which we'll see in our day-to-day handling over the coming months. So it's very much watch this space when it comes to post-litigation costs, any sort of arguments over vulnerabilities, any complexity banding arguments, and it's something that we'll just continue to monitor and adapt our strategy on as we move forward. We're working again with panel on this as well to sort of share insights and just to ensure that we're doing the right thing. So I'll now pass you over to Michael, who will touch on claimant behaviours and the potential impact of the changes.
Thanks, Suzanne. So yeah, if we just move to the next slide. Thank you. So I'm Mike Richards, Casualty Fraud Investigations Manager, and I also lead our Know Your Opponent working group. So without a crystal ball, it's very difficult to predict opponent behaviours stemming from the FRC extension as it's currently in its infancy. But what we can do is look back to where we have seen changes around rules and costs in the past and make predictions based on that. For example, as we heard earlier with the OIC, these changes were brought in with the aim of reducing costs associated with whiplash to reduce motor premiums. But what we've actually seen is a distinct shift in the injuries that are being claimed for. So what I'll be covering is predicted sharp practice. So this is not fraud, but it's those behaviours that when we do see them, they leave a bad taste in our mouth. And the first is potentially an increase of complicated cases. So in essence, making a case as complicated as possible is in the financial interest of claimant solicitors. This may include suing all potential defendants, obtaining multiple expert reports from a range of disciplines, and even making applications stating more than 16 hours is needed for the trial, all in order to escape the fixed recoverable cost regime. Secondly, a rise in cases valued at over 100,000. So as the financial cap of fixed recoverable costs is 100,000, it is highly likely that more claims for loss of earnings and loss of earnings capacity, so Smith and Manchester awards, will be made. And again, a similar pattern to what we're seeing within the OIC. Some panel firms predict that we will see a real decline in cases where the stated value is between 60,000 and 100,000. The next one is early Part 36 offers on liability. So as Suzanne referenced, claimant solicitors will get a 35% uplift on their costs if they beat a Part 36 offer at trial. So I do expect to see claimant solicitors will start making early Part 36 offers on liability. 90-10 split offers on liability, I think, will become a regular occurrence. So the fourth one, going into the world of fraud, is suspect fraud cases being argued as complex. So there is undoubtedly a risk on suspect fraud cases that claimant solicitors will argue that the cases fall within the highest band on both tracks. We therefore may now start seeing, following a request for further information to validate a case or discrepancies being highlighted, that arguments around banding rear their head. Could even claimant solicitors drip feed information to intentionally encourage that further investigation and validation, and then banding arguments will be raised. The next one is manipulation of rules around vulnerability. So as drafted, the rules appear to be an escape from fixed recoverable costs, and it doesn't appear that there will be any limitations to the same. So again, are we going to see sharp practice in this area? And lastly, solicitors hiving off work. So disbursements, I think, are really likely to be a battleground as solicitors try to hive off work, particularly on an agency basis, to maintain their fixed costs. So a new generation of specialist legal representatives is likely to appear, with potentially such advice being claimed for on a regular basis. So this is definitely something we need to monitor going forward. So that was a whistle-stop tour of some of the predicted behaviours. At Zurich, we've created an internal site where guidance for handlers is provided on how to deal with these behaviours when you see them, and also log new behaviours and opponents going forward. So yeah, that's the end of our section. I'll now hand you over to Ella, who's going to discuss our next topic, third-party contractors.
Thanks, Mike. Carl, can you just make the slides on, please? Thank you. So my name's Ella Baker. I'm joined by my colleague Alan Hawkins today, and we've put some slides together just to give you a brief overview of the claims involving third-party contractors and how these would sit within a highways, a landlord and tenant, and an occupiers scenario. Please do bear in mind, whilst we will try and cover all the key points, obviously in the time we've got, we can't go through every possible claim scenario. So looking at contract for services or contract of services, whilst our customers such as local authorities, housing associations, businesses employ many staff to maintain and support their business, it is often more economical to employ independent contractors to do specific tasks. And examples of this would be things like carrying out annual gas safety checks, having people that are out of hours, people that would deal with floods and so on. And sometimes it can be difficult to know the difference between a direct employee and an independent contractor. So the general test would be who is in control of that work and how that work is performed. So generally, an employer is responsible for the wrongdoing of his employee, but not for the wrongdoing of an independent contractor or agent. However, this rule can often vary by statute. So if we move on to the next one and we look at highways first. A highways authority has a non-delegable duty to maintain the highway. However, if the contractor's negligence is unrelated to the condition of the highway, so for instance, if the accident has resulted from the contractor's negligent operation of traffic lights or misplacement of traffic cones, then the claim can go straight to the contractor for settlement. But if the accident was caused by a lack of highway maintenance, the authority has a non-delegable duty in that respect. And the Act makes the authority and nobody else responsible for the maintenance of the highway. In practice, though, the authority is entitled to indemnity from its contractor, either expressly or by virtue of an implied term under that contract. Therefore, such claims can invariably be referred to the negligent contractor, and we'll talk a little bit more about sort of redirections and recoveries as we go on. So next, we want to look at landlord and tenant. It's not uncommon, especially in the case of smaller registered social housing, that the landlord will instruct contractors to undertake repair work on their behalf. In this scenario, again, it is a non-delegable duty, and as such, best practice would be to reach an early settlement when there has been negligence or breach of duty, and we would then assess the prospects of any recovery. However, if the work has been carried out by contractors and it has been performed negligently and without reasonable care and skill, then there is still scope for the landlord to seek a contribution or an indemnity from those third parties. After all, it is the contractor who is in control of those works and not the landlord. And then lastly, if we look at occupiers, this is claims pleaded pursuant to the Common Law Negligence and Section 2 of the Occupiers Liability Act 1957. Don't worry, I'm not going to go through this whole slide, and we will share the slides after, so you'll be able to go through it in your own time. But it does say here, the occupier is someone who exercises control over the premises, and this would therefore apply to visitors of those premises. This means that the landlord may have a defence in claims for accidents caused by negligent work of the contractors in the communal areas if the landlord can show that, one, they've acted reasonably in entrusting those works to an independent, competent contractor, and two, that the landlord has taken such steps, if any, as he reasonably ought to, in order to satisfy himself that the contractor was competent and that the work has been done properly. And this can be evidenced by way of a tender process, so showing that the competency and track record of an appointed contractor, showing that it's been assessed and providing evidence of that contractor's qualification. It is crucial that we're able to show that reasonable steps have been taken to ensure that the landlord is satisfied of the job being done. So if we have a look at just a bit of best practice. Next slide, please. Thank you. We've talked a little bit about the individual statutes, and I appreciate it's a really brief overview. But we just want to flag some best practice advice, which is going to support you and your insurer when it comes to hopefully defending and or redirecting some of these types of claims. So comprehensive contract agreements. So these should include details of roles and responsibilities of each party, confirmation of that they have insurance, and ideally the identity of that insurer. And it's also really important that we're able to access these documents. You know, often they are stored centrally or by another part of the business, and they can take some time to obtain. So that's quite important. Then we've got performance monitoring and evaluation. So for larger contractors, this is something that would usually be ongoing throughout the works. Therefore, it would not necessarily expect checks to be made on smaller jobs. So we appreciate you wouldn't necessarily give the same amount of care to sort of a large contract that's going on for years as you would for sort of ad hoc jobs. That being said, we would suggest that you retain copies of any quotes or correspondence with smaller contractors, as this is going to help you demonstrate that you've appointed a competent contractor. And then lastly, performance review and lessons learned. If during the works or after you've had issues with contractors, how are these being addressed? What changes would you make next time? And making sure that you document these, and these are all going to support the instruction of that competent contractor. And then finally, last slide, please. Just some things to consider and things that we will consider as your insurer when we're assessing these types of claims and the possible recoveries. So as it says here, be pragmatic, We would look to discuss liability with the contractor and or their insurers at an early stage, explaining what our concerns are in respect of liability and why we believe that the fault should lie with them. If they don't agree, asking them why, attempting to narrow the issues. If the contractor can be brought on side at an early stage, it might be possible to agree an indemnity or contribution, or at least an apportionment based on the risk. Be alive to the commercial realities. It is important to keep in mind costs to ensure that any recovery action does not end up being a false economy, i.e. the costs are more than we are set to recover. If the prospects of success begin to look very finely balanced, it may be sensible to reassess whether investing in the recovery is worthwhile. This is particularly relevant when considering adding a contractor into a litigated claim by way of Part 20, as this would greatly increase the costs should the recovery be unsuccessful. Be proactive. If we are able to agree an indemnity early on, then contractors can deal with the claim from the start and or agree to work with us to settle the primary claim, and then we can come to an agreement on quantum, and that is the best way to get a settlement for both parties. And lastly, limitation. Just to bear in mind that any recovery action is subject to a limitation period of 2 years from the date the primary claim was settled. So it is important to consider those prospects early and whether a subrogated recovery claim is sensible as soon as possible. So to summarise, ultimately, we always consider each claim on its own merits. And whilst we will always look to engage with our customers throughout the life cycle of the claim. So I appreciate this is a real brief overview. So do please put any questions in the chat and we'll try and get to them now. And if not, they'll be covered off when the pack's sent round. So thank you very much for your time. I will now hand over to Julie.
Thanks, Ella, and good morning, everyone. I'm going to spend just a few minutes on the topic of e-scooters, and I'm sure that most of us on the call have had some experience of these devices, whether it's from seeing them on the roads, knowing people that own one, or you might own one yourself, or actually using one as part of the trial schemes that are in place across England. So since e-scooters first appeared on our roads, I think it's fair to say they've been a hot topic for both legislators, insurers and in the media. Public attitudes do differ about these devices. Some have raised concerns around the safety of riders and pedestrians. Others are supportive of the positive environmental impact that they can bring. But I think it's probably fair to say that in the main, there's still some poor public awareness as to the legal status of e-scooters. So where are we now? Well, legal use of e-scooters is currently restricted to the local authorities that are conducting formal trials of rental scooters in England. These were launched in July 2020 and they have been in place in around 32 local authority areas across England since that time. The trial timescales for the schemes have been extended several times since they were first launched. And now the trial scheme has been extended further until May 2024. Rentals usually take place via an app, so that would direct the hirer to a free scooter, which they can then unlock. And once the hire has started, riders are insured for third-party damage through the rental scheme. The scooters are usually speed limited, with most having a maximum speed of 12.5 miles per hour. And they're also geo-fenced to certain areas, which means that they will start to slow down and gradually come to a halt if a rider attempts to remove the scooter from its operating area within the trial schemes. The scooters also feed telematics data back to the trial scheme operators. And most, if not all, hire apps require the user to read some sort of basic safety information and to verify their age before the hire starts. But that is really difficult for hire companies to enforce. And the trial schemes have come under some scrutiny for not doing enough to enforce the use of helmets and to deter unsafe rider behaviour. Media reports on accident rates and a focus upon particularly tragic or serious e-scooter accidents have also influenced public perception. But supporters of the scheme points to the low carbon emissions and the low sort of cost involved in these devices as a travel option. But there is hard evidence that e-scooter accidents result in increased injury rates when compared to a normal pedal cycle. PACS, which is the Parliamentary Advisory Council for Transport Safety, they have carried out quite a bit of research in this area and have found that injury rates for e-scooter users were almost 3 to 4 times higher than that of a pedal cyclist. You can take the next slide, please, Carl. So despite being widely available for sale, private e-scooters do remain illegal when used on roads or public places within the UK. Many larger or more responsible retailers will flag this at the point of sale that e-scooters are only legal to be used on private land with the owner's permission. But equally, just as many retailers do not flag this. And I think that contributes overall to maybe the public awareness remaining quite poor. And this has led to some criticism on retailers for contributing to that lack of public understanding. With some scooters being marked as ideal for commuting, without mentioning that this is only applicable if you're commuting across private land and you've got the owner's permission. So it's now been established that there's approximately 1 million private e-scooters in the UK, so owned by the public, and with the majority of these being used illegally. Police forces are not really adequately resourced to deal with the scale of the problem, with the result that very little enforcement action is taken, save for situations where e-scooters are being used in connection with other crimes, such as drug dealing, essentially. Private e-scooters being used on a road are, by consequence of their illegality, incapable of being insured. Therefore, technically, there is no recourse for any injured third-party claimants. And currently, the Motor Insurers Bureau will pick up claims from third parties that are injured by an uninsured e-scooter rider. And as we all know, the MIB is funded by insurers, which is we all pay a levy into. So in effect, the cost of uninsured e-scooter accidents is being passed on to the premium paying public. And can I have the last slide, please, Carol? I don't know if is that slide changed?
It has on my screen, is it not?
That's it. That's it now, Carl.
Yeah, Julie.
Yeah. So in terms of looking forward to what the future may hold, so if we look back to the Queen's opening speech in Parliament last year in May 2022, it did put in place a transport bill which would improve transport infrastructure, and that this would provide a regulatory framework for e-scooters. It is broadly understood that the government intends to introduce a new vehicle category encompassing low speed or low emission personal vehicles, but there is no word from the government as to when this bill might be drafted and what it looks like. So essentially there's not been much progress since the Queen's speech last year, and it'll be interesting to see if there's any reference to it in the King's speech this year, which is due next week. One of the key headaches for legislators is the insurance position. So some campaign groups and commentators have stated the importance of a compulsory insurance regime, but the practicalities of putting that into place is quite a challenge. If you think about our existing compulsory vehicle insurance, This depends on each vehicle being registered and being identifiable. It would seem relatively easy to ensure that each new e-scooter sold could carry essentially a registration number. But what appetite would there be in the public for these devices if there was a requirement to insure them annually and pay a premium, and how would that be monitored and enforced? There is also the matter of the fact that there's already approximately 1 million that are already in circulation on the roads, so there appears to be no easy solution to this. PACs and other campaign groups, as well as e-scooter industry, are pushing the government to move forward with this and include a transport bill within the King's Speech at the opening of the next parliamentary session, which is on the 7th of November. But whether we will actually start to see some movement on this remains to be seen, given the number of sort of economic challenges and other various priorities that the government have on their hands. So essentially, let's wait and see what comes next. And with that, I'll pass over to Stephen McGee, who's now going to cover the topic of vicarious liability and duty of care.
Thank you, Julie. Just wait for the slide to change. So thanks for the introduction. I'm Stephen McGee and I head up Zurich Specialist Claims Team. I've got the very difficult task of distilling the law in 2 very complex areas into 15 minutes. Let's see how I got on, but apologies in advance that I have to move through this at a bit of pace, but hopefully it'll make sense. So if we just change the slide again, starting with vicarious liability. On the screen very shortly, you'll see all the key cases on what is a very complex and confusing legal doctrine. I will refer to all of them as I canter through the next 5 to 10 minutes very, very quickly, as I said. So the very basic principle of vicarious liability is that an employer is liable for the wrongful acts of its employees. The liability is strict, so there is no need to establish negligence or fault on the part of the employer. For it to arise, there is a 2-stage test to be applied, and the 2 limbs of that test have been subject to a long line of legal authorities considering where they apply. The first element considers the relationship between the employer and the employee, but as we'll find out shortly, we're not always talking about conventional employment relationships in some of these cases. The second element is whether the wrongful act of the employee was within the scope of that relationship of employment. So until Lister versus Hesley Hall on the right-hand side in 2001, the law provided that an employer would only be vicariously liable where the tort or wrongful act committed related to what the employee was authorised to do. Lister concerned a warden within a children's home who abused children who he was employed to care for. Now, abusing them was plainly not part of caring for them, so the claim was defended until it reached the House of Lords, and in this landmark case, the House of Lords replaced the concept of the authorised act with the close connection test and found Hesley Hall liable on the basis that the employer, they put him in a position where the close contact that he was given to children through his work created a sufficient connection and a special risk between the acts of the abuse which he committed and what he was employed to do. So the key principle coming out of that decision was that if the acts, criminal or otherwise, are closely connected with the person's employment, then the employer will be vicariously liable. A decade after Lister, in a couple of claims against religious institutions, GGE and the Christian Brothers cases, the courts extended the scope of vicarious liability to non-employment situations, holding that it was sufficient to show that the relationship between the defendant and the wrongdoer is one which is akin to employment, to use the court's terminology. So it's like an employment situation, but where there is perhaps no contract of employment or payment of wages. The central point is really where an individual is furthering the interests of the defendant, they may well be held liable for any wrongs which they commit whilst doing that. And in the 2016 case of Cox versus the Ministry of Justice, the MOJ were held vicariously liable for the negligence of a prisoner who was working in a prison kitchen as part of his rehabilitation. The key point in that case was that had the prisoner not been carrying out the work, they would have had to have employed a normal employee to do the work, and if they had been negligent, they would have obviously been liable for that. It was held as quite a controversial decision at the time, but I guess it does sort of make sense when we look back at it. We reached a high watermark in relation to the Stage 1 test on the case of Armes versus Nottinghamshire County Council in 2017, another case that went all the way to Supreme Court. In this case, the local authority were held liable for abuse perpetrated by foster carers who they had placed the claimant with, even though the local authority has very limited dealings with how a foster carer will look after the children that's placed with them. So at that point, it became clear that vicarious liability could now be easily argued in any situation where an organisation has delegated functions to another party. And it's a concern for local authorities in particular, because these days they are relying more and more on outsourcing arrangements in order to save costs. And so the direction of the law at this point was causing real concern. And what was a bit of a relief to the defendant community, the development of the law came to a bit of a halt in the case of various claimants versus Barclays Bank. Very briefly, this matter concerned an independent doctor who was contracted by Barclays in the 1980s to carry out pre-employment medical checks on employees, and he sexually assaulted some of those attending medical examinations. The claimants were successful at the High Court and at the Court of Appeal, but when the decision reached the Supreme Court, it was overturned on the basis that the doctor was an independent contractor carrying out business in his own right. That came as a bit of a surprise at the time, because the feeling was that the courts were moving to the point where if an organisation was benefiting from services being provided by an individual, then they could still be held vicariously liable. But Barclays clarified the position in that regard, which has been helpful since. And in a similar case, a year later, the case of SKX versus Manchester City Council, a case where the claimant was abused by employees within a children's home that was held to be an independent contractor, and so the local authority were not held liable in that scenario. Another similar decision was reached in the case of TVZ versus Manchester City Football Club, which involved the acts of the infamous Barry Bennell. There, Barry Bennell was found to be an independent contractor and not in a relationship akin to employment. And then again, the same decision was reached on a very similar case of DSN versus Blackpool Football Club. So moving over to Stage 2 again, we've already covered Lister, so moving on to Mohammed, which is probably the most talked about vicarious liability decision in recent years. In this case, the claimant, Mr. Mohammed, called into a Morrison's petrol station. He asked the staff at the petrol station kiosk, including a Mr. Khan, whether he could print off some documents that he had stored on a USB stick. Mr. Khan told the claimant in no uncertain terms that they didn't do that, and he told him to get out. He then followed the claimant out to his car and beat him up in the forecourt quite aggressively, quite severely. The Supreme Court held Morrison's vicariously liable on the basis that it was Mr. Khan's job to attend to customers and to respond to their inquiries. His conduct, whilst inexcusable, was within the field of activities assigned to him, and what happened thereafter was an unbroken sequence of events. Now, this seemed to represent a further expansion from Lister, as it was not a situation where it could be said that the role that Mr. Khan was performing carried with it any inherent risk that he'd end up brawling with customers, as opposed to, say, for example, a situation where a bouncer is working in a pub on a Saturday night and it requires to deal with rowdy and drunk customers. So the validity of the decision, it's a decision that's been quite queried by legal academics ever since. However, 4 years later, in another case involving Morrison's, the law took a step or two back again, bringing the reasoning for that Mohammed decision into question. So in Morrison's 2, as it's sometimes referred to as, the claimants were current or former employees whose personal information in the form of payroll data had been wrongfully disclosed to various newspapers in a breach of the Data Protection Act 1998 by an Andrew Skelton, who was a fellow employee. Skelton had access to the data because he had been instructed to gather it for provision to Morrison's auditors. He shared the data due to holding a grudge against his employer for subjecting him to a disciplinary procedure for minor misconduct. As it happened, one of the newspapers he sent the data to alerted Morrison's to the breach. Mr. Skelton was swiftly identified and he was subsequently imprisoned for 8 years. The claimants then sued Morrison's for compensation on the basis that they were vicariously liable for Skelton's wrongful disclosure. The Supreme Court overturned the Court of Appeal decision, which held Morrison's liable. They held that Skelton was not acting in the course of his employment when disclosing the data, as it did not form part of his functions or field of activities. It was key also that Skelton was not engaged in furthering his employer's business. He was actually pursuing a personal vendetta. And some said that is exactly what Mr. Khan was doing in the Mohammed case, as his attack was held to be racially motivated. The two decisions are in conflict with one another, and as a result, it leaves us with some uncertainty as to how to deal with some scenarios. And it really does just come down to it's very, very fact specific, basically. So there's no really easy answer to any vicarious liability situation. But we obviously got lots of case law to work with and try to make the right decision with. So just to close off this section, very briefly mention BXB versus Watchtower Bible, a case which was where judgment was handed down by, again, the Supreme Court just a couple of months ago. It was a claim brought against the Jehovah's Witnesses for an act committed by an elder who at the time was not held to be acting in the course of his duties when he sexually assaulted the claimant, who he had befriended previously through his work with the congregation. And finally, another very recent case from the Court of Appeal, MXX versus a secondary school. It considered a case where a Year 8 student was sexually assaulted by an 18-year-old work experience student who'd spent 1 week at the school previously. The stage 1 test was satisfied on the basis that the school had a degree of control over the work experience student, but it failed on stage 2 on the basis that the wrongdoing occurred many weeks after the relationship with the school had ceased. It merely provided them with an opportunity for the two to meet, but it was not sufficient to cross the stage 2 threshold. So that's vicarious liability in a very, very small nutshell, I guess. Apologies that I did canter through that very quickly, but moving on to the next point now, which is duty of care. This is very specific to our ZM customer base, but hopefully still of interest to the wider customer base also on the call. So in relation to public authority liability, the general principle has always been do no harm, as per the slide of the title. What that essentially, this title of the slide, sorry. What that essentially means is that a public authority, and that can be a council, a police authority, a fire service, does not owe a duty of care to the public at large for harm caused by third parties. The reason for that is because if a private individual would not be held liable in negligence, then a public authority cannot be held liable either. The same rules apply to everyone. So like you and me, a public authority does not owe a duty of care to stop the man on the street from being murdered, the building across the road from burning down, or your next door neighbour from being abused by a family member. In that very scenario that I mentioned latterly there is what has been subject to scrutiny by the courts in recent years. My team's been involved in a lot of cases, the main one being CN&GN versus Pool. So this was a case which considered the liability of 3 different public authorities. CN&GN were young boys under the care of their mother. In 2006, they moved into accommodation on a housing estate in Pool. For over 5 years, the family suffered from the most severe antisocial behaviour at the hands of a neighbouring family. The behaviour was frequently reported to the police, the housing authority and the council. Claims were brought against all 3 authorities on the basis that they'd failed to safeguard the children and their mother over the period of abuse. So who was liable for this? Was it the police? One of their key responsibilities is the management of antisocial behaviour. So did they owe a duty of care? The answer was no, they did not, as the police cannot be sued for their negligent failure to investigate or prevent crime. This was highlighted in the 2015 case of Michael versus South Wales Police. It followed the same logic as Hill versus West Yorkshire Police, which was the litigation arising from the Yorkshire Ripper murders, and that may be fresh in the memory of those of you who have watched the ITV drama The Long Shadow, which was on recently. What about the housing authority? They could have moved the family earlier or clearly kicked out the problem family earlier as well. Did they owe a duty of care? The answer again was no, on the same grounds basically, and that was dealt with in a claim known as Mitchell versus Glasgow City Council. So there was no claim against the housing authority either. So with the claim failing against the police and the housing authority, the claimants next went after social services. They had limited involvement with the family due to concerns which had been reported by teachers at the children's school. Did they owe a duty of care? The answer was they may have, based on the case of JD versus East Berkshire from 2004, and that was a case that established that local authorities may be liable under the Children's Act if they fail to remove children from a home where they are suffering abuse or neglect. The CN&GN reached the High Court which held that a duty of care was indeed owed in these specific circumstances based on JD. However, CN&GN was not a case where children were being abused within their own home by the parents, like JD. They were being abused by neighbours. So in short, what was being argued by the claimant solicitors and accepted by the court up to a point was that the council should have used their powers under the Children's Act to remove the children from their mother, so to protect them from the abusive neighbours, using JD as the rationale. Now, that plainly wasn't correct, and it gave Zurich, as the insurer, no option but to take the claim to the Court of Appeal, where the decision was overturned. It was then appealed again to the Supreme Court, where the decision was upheld. The Court of Appeal in particular were absolutely scathing as to how the claim had been pursued by the claimant solicitors, stating that removing the children from the care of their mother would have been utterly heartless and utterly wrong. So we're now in a situation where the law in respect to public authority duty of care is universally the same, regardless of what department or authority it is. It has left the scenario where children are being harmed by their own parents in doubt, however, in terms of when, where and when a duty of care arises. The Supreme Court was keen to point out that there is no immunity from suit, and there are exceptions where there are some exceptions where a duty of care will arise, and those are briefly covered on the next and final slide, if we can just move that on, Carol. So the first point is where there is an assumption of responsibility on the part of the authority, where the authority creates the danger or fails to control the source of the danger. And finally, there is a separate, and this is separate from common law, but there may be an alternative route to damages under the Human Rights Act 1998. So I'll just very briefly go through these points. So looking firstly, assumption of responsibility, and there's a case by the name of Barrett versus Enfield, and that is the key authority on assumption of responsibility, and it held that where a local authority had taken a child into care, that's the point at which a duty of care arises, and they're responsible for any harm which is suffered thereafter. But what about the cases where claimants remain within the family home and are suffering harm of which the local authority may or may not be on notice of? This has been subject to a recent run of court decisions, which I'll just go through very quickly. So first of all, DFX versus Coventry City Council. A couple of years after the CN decision, the case involved 4 claimants who were subject to 15 years of extensive social services involvement. Despite the significant involvement, the court took the view that when viewed objectively, it was not reasonably foreseeable that the claimants would rely on the defendant's social workers, so it could not be said that there was an assumption of responsibility by the claimants. DFX was a High Court decision, and the claimant's solicitors have continued to take claims involving this type of scenario up the court hierarchy, and indeed the cases of HXA versus Surrey County Council and YXA versus Wolverhampton City Council were heard by the Supreme Court over 2 days last week. The circumstances of each claim are very different, but the allegation being made by the claimant solicitors is that where there is extensive social services involvement with the family, a duty of care will surely arise. The defendant's position is that the law has been made clear on this in CN, and there is no duty of care to protect claimants from harm caused by third parties. It shouldn't be any different to what it is in terms of the police, housing authorities, fire services, etc. It'll be to the benefit of all concerned on these cases to get some clarity from the Supreme Court, and it's probably just as well that it has went all the way up to the highest court in the land, because if we can get some clarity on whether a duty of care arises or not, it'll allow us to deal with the claims in the correct manner, and that may well be defend them or get them settled if that's the right thing to do. For about 10 years now, that this type of claim has really been up in the air, and defendants and claimant firms haven't been too sure where to go with them, basically. So we'll see where that goes. Very briefly, a couple of other exceptions are where the authority has created the danger or failed to control the source of the danger. Those situations were dealt with in the case of Robinson versus West Yorkshire Police and the Home Office versus Dorset Yacht. Robinson being a case where the police were conducting an arrest in the middle of a busy high street, and in the course of doing so, they knocked over an elderly lady who suffered an injury. The police tried to defend that claim on the basis that they were immune from suit, but the court said that they are not immune from suit, and where they make matters worse, basically, they're liable for that. So they were responsible in that case. And in the case of Home Office versus Dorset Yacht, the Home Office failed to control young offenders that were held in a Borstal unit, I think it was, and they escaped and caused damage to neighbouring property, and they were held liable in that case because they failed to control the source of the danger. And finally, and very briefly again, I'll touch on the Human Rights Act 1998. So in respect of the failure to remove scenario, Article 3 is the most relevant part of the Human Rights Act, as it deals with the prohibition of torture, inhumane and degrading treatment. And since the CAN decision, most ongoing claims have been reformulated to include alleged Article 3 breaches. The first case to test this was heard by the Court of Appeal in April in the case of AB versus Birmingham City Council. The legal considerations under the HRA are very complex, but the main points to satisfy are that the defendant must be on notice of real and immediate danger, and a threshold of seriousness requires to be met. The claim in AB failed because the threshold point had not been met, because the child in this case had been subject to neglect rather than physical or sexual abuse, and had that been the case, the threshold probably would have been met. However, the real battleground in this sort of area will be what is meant by real and immediate, what is meant by notice of real and immediate danger. The advice we've received so far from our legal solicitors and counsel is that the test that will be applied won't be too far removed from common law principles, but the case law will no doubt develop in the years to come. And I doubt, even if we get clarity on HXA and YXA in respect of common law, we'll be subject to further years of litigation on the Human Rights Act. So that brings the webinar to a close, I think, and we go into Q&A. Carol?
Yes, thank you very much, Stephen. I'm going to stop sharing my screen because I think there is a slight delay. We do have some questions that have come in. So if I could ask my colleagues on the call to sort of listen out, and if there any question sort of appears as though it's best answered by them, that'd be great. I think the first one might be something for you, Ella. It's to do with the non-delegable duty or strict liability. Then what's the point in carrying out inspections of the highways if we're going to be found liable in any event?
Good question. So I suppose it's twofold. If it's occupiers, then obviously we would then have defence had we done our inspection. So that's the first point. But I suppose when you're talking about the ones where we've got that non-delegable duty, whether we've done the inspections or not, the advice we would always give is, by doing those inspections, you are more likely to pick up defects earlier, and therefore they're not likely to appear, and then you're not going to get these claims. So while sometimes it can be very frustrating, and we totally appreciate that, we would always say it's much better to have those inspections, because that is how you're going to pick up things that's going to completely prevent the claims coming in the first place. Is probably the sort of, in a nutshell, answer.
Okay. Thank you very much. Sorry, I just realised I didn't switch my camera on. Do apologise. No great loss, however. So, quick question for you, if I may, Michael. We focused on the 6 behaviours and the sharp practices you expect to see as a result of the FRC extension. Do you think that they'll be limited to 6, or do you think there's some more out there that we need to anticipate?
Unfortunately, Carl, I don't think there will be a limit on the number of sharp practice that we will see. And my view is that certain opponents, where they see opportunities to increase costs, they will undoubtedly take them. Another predictive behaviour that I didn't include within the slide is one that, from a post-litigation perspective, I do think there may be a potential to refuse to grant extensions for the filing of defences in claims that are likely to be allocated to the intermediate track, as they are seeking to receive their pre-litigated costs as soon as possible. But as I alluded to before, it's essential we track the behaviours, and I think it's necessary that we can, by doing that, we can then employ specific strategies to be able to deal with them. So yeah, there may be certain behaviours we didn't envisage, and of course satellite litigation, I think, generally will be important on this topic, just to monitor as we go through.
Thank you, Michael. I see there was a question in the chat that you've already asked about the inclusion of additional injuries that appear possibly fraudulent or exaggerated. Can you just expand on that just for everybody if they haven't had a chance to read it in the chat, Michael, if that's okay? You mentioned a case of Gray versus Holmes. Is that?
I think that's
Martin, isn't it?
Martin. I think I'll
apologies.
hand over to
I'm trying to do two or
Martin.
three things at once, and I've failed.
It's all right. So yeah, it was a really good point. So as I flagged that we have seen an increase in the non-tariff injuries coming into play within the OIC, so there is a lot that we can do. I'd mentioned the case of Gray v Holmes, where it stipulates that a medical report and the medical examiner should detail how these injuries have come about, and that's something that we hadn't seen initially. We are starting to see a bit more of it now as solicitors' behaviours adapt, but there's other things that we can draw upon to argue for these cases, such as drivers' description at the scene. I think days gone by in MOJ where it was majority whiplash, we couldn't really use the description of the driver at the time of the incident because the onset was potentially 24 hours plus after the incident, whereas these non-tariff injuries where people are banging their knees or elbows or ankles and jarring them on the steering wheel, they are for such long periods of time that they should be evident at the point of the collision. So if there's any footage that we've got or a driver's description of how the claimant has moved about immediately after the incident, we can use that to challenge these cases. We can also use within the medical report as well the onset time. Like I say, these injuries should be evident at the time of the incident, given the long prognosis periods claimed. But often in the medical reports, their onset is in line with that of the whiplash claims. So they're still using the same tactics to try and pursue these cases. So if we can align a lot of these instances up, it puts in a really good stead to challenge these and dispute them where we can. And then I think there was another bit around how we track solicitors and medical examiners' behaviour, and we're able to do that through our MI quite easily. So we can, and we do track the injuries that are presented, the prognosis periods that are presented as well, and you can tell that if certain solicitors, all their cases have a non-tariff or all their cases have a psychological element, so that obviously you would expect to see some cases in that, but not all. So off the back of that, you can do things of know your opponent to hone in on those areas.
Thank you so much, Martin. Couple of questions, if I may, for you, Julie. Are there any plans for e-scooter trial schemes in Scotland, and what are the aims of the trials ultimately?
Thanks, Carl. So on the Scottish point, no immediate plans to get e-scooter trials in Scotland. I think it's fair to say that the Scottish Government and sort of some local authorities in Scotland are really interested in the trials that are taking place in England and monitoring the output of that. And I think there's definitely within the public a growing interest in what's going to happen with regulation on e-scooters to ensure the safety of all road users. But in the immediate term, there's no sort of immediate plans to lodge trials in Scotland in the same way as there has been in England. And then in general on the aims of the trials, so if we think back to 2019, that's when the government first published their sort of Future of Mobility Urban Strategy. And it was within that document at the time that the Department for Transport identified that substantial changes to transport in major towns and cities would change and become inevitable. So as part of that review, the government identified e-scooters as a sort of fast and environmentally friendly means of transport. And they wanted to have a forum in which they could test these devices out. So to test, obviously, the running of them, the appetite within the public for the use of them, the safety aspects, and also what sort of impact it might have on the environment, in people's day-to-day travel. Would they reduce using car journeys for shorter journeys? And would it have health benefits? All that sort of stuff. So the aims of the trials are to sort of, test the appetite for these, establish what the kind of environmental impact is, but also monitor safety and health, etc. So that's a sort of general view.
Lovely, thank you, Julie. I've got a couple for you, if I may then, Suzanne. The first is in regard to Part 36 costs. If a judge awards an amount over and above our offer, but below the claimant's offer, are they entitled to an uplift in costs?
No, so the claimant will only get that uplift in costs if they're if the judge's sort of award is the same as or above what they had originally valued it at. So if, for example, if they met them in the middle of our offer and their offer, then it's just normal fixed cost apply there. They'll only get that uplift if their own offer has been met or exceeded.
Oh, great, thank you. And just another one for clarification over timings. If a claim happened in July, but it's intimated after October, will they be bound by the new cost regime?
It depends if it's personal injury or not. So if it's a personal injury claim, the accident, if it is after October, and the accident needs to be after October this year, basically, for personal injury claims to be scooped up into the fixed recoverable costs. If it's a credit hire, for example, and that claim it was intimated before October, but then issued after that date, then it will be the fixed recoverable costs that sort of come into play, which has a real benefit when it comes to settling those cases.
Oh, that's great, thank you. I think there's a question in the chat, Ella, that you may have answered, but it's saying, are you saying that if a loss or damage arises from a negligent act of a contractor, then the landlord should settle and seek recovery, and that we should not be redirecting to the claimant, to the contractor at that point? Can you just sort of expand on your answer, please?
I can, if I can just find my answer.
Sorry, I'm just trying to find myself as I'm going through.
So as I put here, that is the legal position, and I think somebody's mentioned, that it's not exactly as they said in their comment. It's not a strict liability. It's that it is a non-delegable duty. So you still have your Section 58 defences and things with highways. With the landlord-tenant scenario, there does have to be a landlord-tenant relationship there for that non-delegable duty to apply. And again, as I've said in the reply, we do deal with each claims on their own merits, and we would always look to engage early with the contractor with a view to redirecting where possible. I think it was just really trying to highlight the importance of sometimes because that is the legal position, we have to make sure we do the right thing by all parties, but that will absolutely include engaging with our customers and redirecting those claims whenever we possibly can. I think someone's asked as well, just around a scenario about contractors going in to do perhaps other works and then causing damage. I suppose it'd be very similar to the sort of highway scenario where we mentioned if it's not to do with the sort of fabric of the highway, so if they're doing temporary traffic lights, so similar scenario, if they're going in to fix a boiler and whilst they do so, they damage a worktop, certainly from a claims perspective, whilst that non-delegable duty is there for a landlord and tenant, because it's done sort of in the course of the works they're carrying out, aside from the course of what they're there to do, I would certainly be looking to send that to the contractors in the first place. But again, each claim on its own merits, and we would have those discussions early with both our customers and the contractors.
That's great, thank you very much. One for yourself, Jennifer and Martin, if I may. You mentioned that there may be an increase in litigation due to liability. Is there anything that we as customers can do to protect ourselves from this?
Yeah, I'll take this one. So essentially, ensuring we have evidence is the easiest way to resolve a liability dispute. So Dashcam is brilliant in allowing our claims handlers to quickly assess liability and resolve the dispute. So if that is an option, we would really encourage it. Also, it is a requirement of the OIC process that a defendant has a statement of truth from their driver. So in order to dispute liability, we need that statement of truth from the driver. So encouraging drivers to cooperate with us is really important, as without them, we can't dispute. Just regarding the statement of truth, unfortunately, many of the accident report forms that we receive from brokers or customers, if they have their own, are not always statement of truth compliant. So we have to return to the customer for a compliant signed statement of truth. We do have some customers that have amended their accident report forms to become compliant, and this has been useful in allowing us to ensure we have everything we need to pursue a liability dispute and also to avoid duplication for the customers. So yeah, evidence such as dashcam and the cooperation of the driver are the most important things, really.
That's great. I'm just conscious of the time. I think there was one more e-scooter question, Julie. So we're happy to take these away if need be, but if we've got got time, or whether you prefer to sort of put a response, I can't find that now, so it may be that we respond separately.
I saw Carola's one from Karen Dawson in the chat around does this apply to e-cargo bikes?
That's
as
the one
many
I saw, yeah.
councils are entering into schemes where they hire these out. So I can answer that quickly. So essentially, e-bikes are classed as electrically assisted pedal cycles. So they are, majority of them are legal to use as long as the bike meets the requirements of the DVLA's rules around those devices and the categorisation of those devices. So the key points are that the pedals will need to be in motion for that electrical assistance to be provided, whereas the difference with e-scooters is essentially, there's no pedal motion involved. It is purely a light electric vehicle classification, so there is differences. So I would just say it should be okay as long as the e-cargo bike meets the DVLA's rules around electrically assisted pedal cycles.
That's great, thank you very much. And what I will do is at the end of this webinar, I'll go through all the questions. If there's any that we haven't been able to cover, when I send over the slides, when we send over the recording, we'll include any answers that we've been able to cover now. I will be also including a survey that if you could take some time to look at, go through. We will be planning for our 2024 webinar programme in the not too distant future, so any guidance or thoughts, suggestions that you may have to give us some direction would be appreciated. So it all remains from me to say thank you to all my colleagues who took the time to prepare the content and deliver this morning, and also to you for attending and joining us and spending an hour and a quarter with us to understand a little bit more about some very interesting topics. So I'll wish you all a good day and say thank you very much and goodbye.
Thank you.
Cheers, everyone.
Thanks, everyone.
Thank you.
Bye.
Bye.